resources from the Coast Salish territories and to foster connections with local Indigenous communities. By doing so, you can gain a deeper understanding of how to advocate for educating for others about these important issues. All right, I'm officially going to introduce James McBain. So, once again, James is Senior Vice President, Regional Director of Wealth Planning and Trust Advisory for U.S. Bank. His career reflects banking and financial services, specializing in implementing multi generational estate plans, among other philanthropic plans and efforts. James is also a beloved United Way of King County committee member and a highly appreciated member of our community. Please join me in welcoming James. James, welcome.
Oh, thank you, Anna. That's so kind of you, and I'm so delighted to be here. I'm just so pleased with the organization, and I treasure my involvement with the committee. So, and thanks to everybody for joining us for this Create a Legacy Estate Planning Fundamentals session. I'm going to walk through in this session a lot of estate planning topics. There should be a lot here in terms of language on the slides, and hopefully some of the diagrams will help as well. And if you need follow-up, I think we're going to make copies of this available so people can have a look, because I know there is a lot, and I apologize for that in advance. But let's jump right in. Why is estate planning important? Kind of why are we here? I think the first slide kind of gives a whole bunch of reasons for why people plan for their legacy, whether it's taxes, whether it's protecting family wealth, or trying to maximize family wealth and really hold on to kind of what's there. It's really all about following the wishes of the people who are creating the estate plan, who are trying to design kind of what they have to know that their wishes are going to be written down on paper. They look at beneficiaries, whether somebody struggles with managing wealth as a spendthrift. They really do focus on, and I'll spend a bunch of time on this today, on naming the fiduciaries, the people who have jobs in an estate plan, whether they're an executor or personal representative of an estate or a trustee, or a lot of other roles where people need to serve to help you out in the event that you pass away or that you become incapacitated. So those are kind of the reasons. And that last one, provide for the surviving spouse. I tend to think that's kind of usually our starting point for married couples, is thinking really hard about how best to do that. So if we can flip to the next one, Mari, that'd be great. So what exactly is estate planning? So it's instructions. It's a list of what you want to happen. And an estate plan includes a bunch of pieces of paper, and I'll talk about those documents here in a minute, but that really focus on making sure that your wealth and your values are kind of expressed in writing. If you have young kids, I actually also think that the big point is naming a guardian for the children. Make sure you know where the kids are going to live while they're grown up, and who's going to be able to sign the permission slips to go on the field trip from school. Manage the money for them and make sure that they're taken care of. Really looking at some of the things before somebody dies, for powers of attorney, for making medical decisions or financial decisions. All of those things go into what an estate plan is. And people often say, well, what's an estate? Is that just the house? Well, if you have a large house, maybe that is an estate. But what we're getting at as advisors is an estate plan is really dealing with an estate of all of the property that you own. Everything, your investments, your house, your business, your tangible personal property, things you can touch, furniture, automobiles, things like that. It's really everything that you own and where you want those things to go. So that's kind of what exactly estate planning is. Let's go ahead and flip to the next one here as well. So what documents are in an estate plan? Well, everybody always starts with the will and thinks that the will is kind of the most important piece of the plan, and it's very important because it really does say where things go on death, and it appoints who those fiduciaries are going to be, whether it's the executor. And I'm going to start using the term personal representative. It's the same thing, but Washington uses personal representative as the person who administers an estate on death. It's all sorts of other things that we want to think about too for kind of a living trust, which might be what the document is that really says when people are going to get the wealth coming out of the estate. It's the healthcare directive. We spent a lot of time talking about this about 30 years ago when I kind of was fairly early in my practice, looking at instructions for kind of living wills and how people pass away if they're permanently unconscious, and life-sustaining treatments only prolonging the process of death. Durable powers of attorney, like a financial power or a healthcare power. I actually think those might be the two most important parts of an estate plan, because you're still here. And for a lot of people, they're really worried about what happens when they're still here, where the will isn't going to have any effect until you pass away. And then I've got in the middle here, this not all assets go by a will or a trust. And that's true. A lot of other assets pass by a beneficiary designation, like for a retirement plan or life insurance, or even the way accounts are set up, where you have something set up where it's a joint tenancy type account. So Those are kind of the documents that are picked up here. Let's go on to the next one and start talking about how they pass. So 4 ways, this is just kind of a general overview that I like to put out for people as to how assets pass at death, because a lot of folks believe everything goes by the will, and that's not quite true. So you can have a probate, which is where the will gets introduced and the will then says where things are going to go. That's over on the far right of the slide. But there are also other ways. And I mentioned beneficiary designation. That's essentially a contract that says those assets are supposed to go to those designated beneficiaries, 401k, IRA, things like that. Those are the ones people think about the most for life insurance. They can go by operation of law, and the most common ones there are joint with right of survivorship. So an account that has that JTWROS, joint tenant with right of survivorship, really just says on death of one, everything goes to the other one. And then a trust, and we'll talk about trust later on. I think that's kind of one of the cornerstones of any estate plan is going to have a trust that really lays out your wills. So that's kind of high level. 4 ways they go. So it's will, it's beneficiary, it's trust, or operational law. Those are kind of the big 4 in terms of how assets are going to move when somebody passes away. So if we can flip to the next one. So here's the terminology. And if you have questions later on, don't let me get away with not level setting, because I want to make sure we're all on the same page. An estate, all of the property owned by the decedent. A will, a legal document that directs the transfer of property on death. Also appoints this personal representative, who is the person appointed to do all of these wealth transfers, whether it's retitling a house and doing a new deed to property, whether it's going into the bank or going into the investment firm and saying, hey, we need to change the ownership because this is what the will says. They're the one appointed by the court, and I'll talk about probate here in a minute, that court proceeding, to make those transfers. Then the guardian. And again, if you have young children, the most important reason you do a will is this one right here, naming a guardian, the person or persons appointed by the will to take care of any minor children. And it could be also, if you have somebody who is subject to a guardianship, there might be a reason for continuing that as well. But the point is, this is naming that person who's going to be there. I think it's the most important thing that you're going to do. If you have the young kids, this is the highest priority, is figuring out who that's going to be. In the absence of naming a guardian, passing away where there's no surviving parent and there are minor children leads to a court proceeding. What's often referred to as the dueling grandmother's problem, as to which grandmother is the better place for that child to reside. And most of my clients, when I was in law practice, most clients did not like the idea of going to court, and good for them, because they should try to plan around having to go to court. Probate, the process of transferring property at death pursuant to a will or by state law, if there is no will and we have to rely on that. A trust, this is one that people always worry about. They think a trust is something esoteric, hard to understand, only for very, very wealthy people. That's not true. A trust is an agreement or a relationship between 3 people, a grantor, the person who creates it, the trustee, the person who's holding whatever the assets are that we're holding in trust, and then the beneficiary, the person who is ultimately going to receive any of this trust property. So this could be oral. This could be me handing over to Anna, hey, would you hold this property in for my kids and help them with their college education? That's a trust. I'm the grantor. I created it. Anna's my trustee. She did such a nice job opening this up. I trust her. She'd do a great job. She's going to hold on to that, and the kids are the beneficiaries. She's going to help pay for college. Now, you got to write that down. Doing oral trust is pretty risky and not recognized in a lot of states, but that's all a trust really is. So that trustee, that fiduciary role of holding property for someone else is a big, big job. And we'll talk a little bit about that later on. The beneficiary, the person who's going to receive the property, and there are reasons to hold in trust so that you don't just hand things off to a beneficiary, especially a minor beneficiary. And then powers of attorney. Again, feel so strongly about this one. This is in the event of incapacity. And most people think of this in terms of dementia or Alzheimer's, having somebody appointed to make sure that the bills can get paid on time or that healthcare treatment can be consented to. So important. They're fairly simple forms, quite honestly. It's a fairly easy to do thing to do this form and comply with it. But it's so very important to think about who is that person going to be? Who is a good choice to be a power of attorney? So that's kind of the basics for the terminology. Let's roll to the next one. Well, let me make sure I don't forget to talk about community property also. So Washington's a community property state, and what that means is community property is all the property that's earned or received during a marriage. So husband and wife are married, they're both working, any of their income is presumed to be community property if it's received during the marriage. Does not include gifts or inheritances. So if somebody gives one of the spouses property, either pursuant to a will or just by making a gift, that is not presumed to be community property. It's separate property. And the reason for that is the assumption is that someone else outside the marital community could make a gift, and their intent might be to only benefit one member of the marital community. So that's preserved as separate property. Now, spouses can freely convert separate to community and vice versa if they want to. It should be done generally by an agreement or at least something acknowledged so that the parties are intending to do that, because titling alone in Washington is not sufficient in terms of creating something or making something into community or separate property. The presumption is when we look at assets during a marriage, the titling is not going to overrule the fact that the source of the funds, if they were earned during the marriage, that's going to be community property, unless we can kind of figure out that they might have come from somewhere else, whether it was a gift or whether it was an inheritance. Okay, if we can go on to the next one. I want to talk a little bit about probate. So probate is the process of introducing a will in court, and opening up a court proceeding, and getting someone appointed as a personal representative of an estate. That's really all it is. Probate is scary to people, and you'll see things talking about how you need to avoid probate. Probate's awful. It's going to cause all sorts of problems. Generally, no. Certainly not in Washington. We are a frontier state in many ways. That probate here is very simple. And especially if you have a will that appoints somebody as a personal representative, it's very much a do-it-yourself type of state. You do not need court authorization to do a lot of things if the will properly appoints a personal representative. The best way to do that is to name somebody who could be a personal representative, which is usually somebody over the age of 18 without felony convictions or fraud convictions, who has capacity and can serve as a personal representative. So those types of things, once you do that, and you can do it where you say, hey, I don't want them to have to post a bond with the court, and then they're appointed. And once we give them the power to serve without court intervention, they're really going to be the ones retitling property or changing up the accounts or doing whatever needs to be done following the death of somebody. So the probate process here, I think, is a very good one. It's fairly straightforward and fairly inexpensive. There are many other states where it is not that way, where probate is phenomenally expensive, and largely that's because the court is required to approve a lot of asset sales, a lot of transactions. So every time you would want to do something, you'd have to go to court. So we're fortunate that we don't have this here. Washington probate also allows the settlement of any claims against the deceased person. So those are gathered up and paid by the personal representative to the extent that there are assets to do that. It's a very kind of organized, routine process to notify creditors, have them file claims, and have them get paid. And it's nice because it settles it off. One of the big things that people worry about is a sense of, oh, if my parents have some debts and they leave assets to me, am I going to owe on their debts? And that's a big issue that you have to look at in a probate. Generally, the probate estate first has to pay for those debts. So if the parents are insolvent, that typically does not flow on down to the next generation. Debts are generally going to be extinguished at that level unless there's a guarantee or something else. And then the probate process also is where a guardianship comes up under a will that says we appoint this person to serve in the event both parents have passed away. I bring up probate in other states. If you own real estate, your name is on a deed to real estate. So it would say James owning property in a state like California. If I die, that we'd have to do a probate in California, not just Washington, because that's where the dirt is. That's where the deed is that has my name. And probate is the process of getting the name off of all of these things and having somebody change ownership of that property. So we spend a lot of time finding out where do people own their assets and how should they be titled or how should they pass on death. We can flip to the next one to talk about asset titling in a probate. So we look at things like community versus separate. Community property does not automatically vest in the surviving spouse on the death of the first, unless the account says that it does, or unless there's a community property agreement or something that says it has to go to the survivor. So just be very aware, just because things are a community doesn't mean it all vests in the survivor right away. Now, people do community property agreements and say, yeah, go do that. But a lot of times we're still looking at having to do a probate to get the spouse's name off of it. We look at separate property, and we look at things where a trust might be an owner. That's outside of probate. We don't have to worry about that one. So the other things in probate also are the things, like I said before, that override a will, which is a power of a payable on death or a joint tenancy or any of the beneficiary designations. Let's talk about the problems. Because a lot of people would come in and say, well, hey, what happens if I die without a will? Does the state get everything? No. State law will say where it goes. And most states, Washington included, are actually pretty good at trying to figure out where you might have wanted things to go. So it's going to govern who takes what share. State law is also going to be what we look to for just some of these default type provisions as to who gets paid, or do we have to, have a bond posted for our personal representative of the estate if there's no will that says what to do. The guardianship with the children just turns into a separate court proceeding. There might be tax complications if you die without a will in terms of who's going to get or who's going to own property. And then probate can be more difficult because we don't have a direct, here's who we wanted to appoint under the terms of the will. The court oftentimes is going to have to try to search, or at least hold a hearing to figure out who that personal representative ought to be. Now, I talked about the second one. We've been talking about probate, but I want to come to this one here for a minute. What happens if you become incapacitated without a power of attorney? Much as I said, probate here in Washington is pretty straightforward, or I think pretty easy and fairly inexpensive compared to a lot of other states. Guardianships are not. So a guardianship here is to be avoided by a power of attorney if you can, because it is a full hearing to try to figure out who should serve to make decisions for somebody if they're incapacitated. So because of that, being incapacitated and not having a power of attorney is something to be avoided. Powers of attorney are easy. You ought to do it. If you don't do it and you need to figure out who can sign checks or who can transfer money in an account, you're going to have to go to court, get a guardian appointed. They're going to have to be the one to do that. And then they have to report back to the court as to how they're spending the incapacitated person's money. Not a great answer. And it also leads frequently to family decision-making problems in terms of, hey, why was this person appointed? Or why did we not get, say, two people if that's what everybody talked about and they wanted? Better have it written down. And then medical decisions. Boy, the most emotional one out there is if somebody's incapacitated, who's going to make these decisions? Everything, including end of life, if there's no direction from the incapacitated person. But that's why these two things alone, kind of having a will, having some direction as to where to go, and having a power of attorney, I think are so very, very important. We can turn to the next one, please. The no will plan. So this is the one where you don't have a will. Folks worry it all goes to the state. It doesn't. Surviving spouse gets all the community property outright, passes to him or her outright. If there's no spouse, it all goes to the kids outright. And if there are no children, then we look to the parents. State law is really trying to find somebody to get the money. They're going to look first kind of over to the spouse, then down the family tree. And if there's nobody there, we look back up the tree. And before you start looking over to the branches, which is a possibility, only if we can't find anybody at all does the state get a portion of the estate. I don't mean a portion. Taxes may take a portion as well, but in terms of where it would go on death. So that's what the no will plan says. For separate property, spouse gets half and the kids get half. It's one of those things I think is really important for people to think about, is especially if you have minor children, the no will plan could be handing significant separate property if it happens to minor children. If there's no way around that, that's tricky. You need to have a will. And then if there's no kids, then the spouse gets 3/4 and the parents get 1/4, then we look to siblings. So again, there's a lot here. The point is that it doesn't just go to the state of Washington. We look for family first, and this is in many ways thought to be the most logical. So here, I think, of all the things I'm going to try to talk about today, this is a nice little checklist. Key decisions for wills and trusts. Who's going to act on behalf of the decedent, which is guardian for the kids, trustee of any trust, and personal representative of an estate. And then some of the tough choices. Where does the guardian live? If the kids are young, and the thought is we're going to have to move them out of state or move them to a different school district, that's certainly something you have to think through. If the grandparents are listed as guardian, could they really serve until the kids are 18? And at 18, even children, they're emancipated. They're considered to be adults. There's no need for a guardian. Most of the kids are over 18 years old. That's the age of majority in Washington and most states. How about when will the kids receive funds? So if we're going to hold money in trust or hold money for children, when should they get the money? That's a big choice that people have to look at. Should they stagger the ages? Should they hold for a long time? Or should they just give it outright? Those are the choices that folks are always up against. And how about assets held for other people, whether it's parents, grandparents, siblings, cousins, whomever? Who else do you want to benefit? And then the one that's not on here that we'll get to later is talking a lot about charity or philanthropy, because a lot of people do have that. And if you don't write it down, then no one's going to know what you wanted. Maybe your family members would make a gift on your behalf, but write it down. Those are part of the choices that are along the way as well. Let's go to the next slide, please. So trust. I've talked about trust. It's that relationship, right? Grantor, trustee, beneficiary. What types of trusts? Again, lots of news about these things. A living trust, by far the most common. It's a trust that's used for titling while both grantors are living. The point of doing it is just for avoiding probate, making sure that everything, the trust governs when people get everything, and we're not waiting or having to distribute according to a will and presenting that in court. There's no tax benefit to a living trust, just so we're clear. You don't get a big tax break. There's no extra deduction. There's no charitable. Nope. A living trust does not have a tax benefit. It is used for titling and avoiding probate. So you'll hear the term testamentary trust. Like a will is actually the last will and testament. Go figure. And so a testamentary trust is one that just shows up when someone dies, pursuant to their last will and testament. So it's created under the trust, or the will creates a separate agreement or directs an agreement to be used for holding assets, but it only really gets funded and arises and has a serving trustee following death. An inter vivos trust. I had 4 years of Latin in high school. I'm proud to say that I get to use Latin during lifetime. So funded with assets during lifetime. Not uncommon, often used for making gifts to kids or grandkids or whomever. And then charitable trusts. And there's a lot of discussion about different types of charitable trusts, and we can certainly go into whatever depth you'd like on those. Really good options for doing things. And there are certain trusts referred to as split interest trust, which like a charitable remainder trust that can provide benefits for the grantor, the person who creates it during life and then pass to the philanthropy or the charity on death. Really great options, but a lot of complexity there as well. Let's go ahead and flip to the next one. So trust can be flexible. You choose when the funds are going to come out. You make the decision. And a lot of times when I bring this one up to people, they say, hey, that kind of hits different than what I might have thought. I assumed that trusts were intended to be rigid, inflexible, would not have these choices or these abilities. Not so. When you create it, you have the choices as to who the beneficiaries are going to be, who the trustee might be. It's a lot of the choices are with the client, with the person creating it. Here's some examples of when property comes out of a trust. The most common by far are attained ages. Turn 21. Used to be 21 is what people wanted. I don't recommend that because a lot of people the night before they turn 21 or probably shouldn't be receiving a big distribution from a trust. A lot of folks like to stagger the ages. Maybe have 3 different points at which the funds come out, say a third at 25, half of the balance at 30, and all the rest at 35. That makes a lot of sense. It makes it easier for the person receiving the funds to get used to it, to understand what it means to be receiving assets and have to manage them on our own. Specific purposes can be included in a trust. I mentioned before, just by way of example, college tuition, very, very common. Purchase of a first home, very common. A lot of trusts also combine these and put all of these things in there and say, here are the ages, but the trustee can also distribute for the house, starting a business, college, all those types of things. You can put restrictions in a trust. I don't want to distribute if the kids have an addiction problem, and we want to limit the distribution so that we don't make things more difficult on them than they might already be. Or we might want to restrict when they're going to receive money if they're involved in a lawsuit or have something going on in their career that might make it difficult. You can have some flexibility to kind of work that out. And my point on this last one, when kids are going to receive their inheritance and how much, it's a balance. For folks with really, really large estates, a lot of times the decision is to try to have them get something and kind of leg into this large amount of money. Other folks just like to say, I don't want to make this choice. They're good kids. They'll be fine. Let's give it to them now. That's up to you. You get to choose. Most people forget about that too as they get older. They keep thinking, well, the kids want me to do this. It's really not their choice. It's really your choice. If it's your will or your trust, you get to pick. You get to say it's where you want to put it. And I can say during a client meeting, when I talk to husband and wife about this, I can say, hey, I am the problem. I am the one telling you you have to do this, and it's not up to the kids. That's okay too. So just recognize these are the things we look at with trust and how we want to work through. Let's flip to the next one on trust because there's some other things too I just want to toss out. Don't forget about taxes. If we're making gifts to a trust, we want to think about the gift tax or the generation skipping transfer tax, which I'll come to in a few minutes. We want to think about the estate tax also, and Washington has one of those along with the federal government. But taxes are a big reason that people do trust type planning. So those are out there. But I actually think the non-tax benefits of trusts are a big reason that people should be focused on them at this point. One is avoiding probate, just not having that court proceeding. It's easy in Washington, but especially if you have houses in other states, it can be kind of tricky. It's not the simplest thing in the world to have to go to multiple places. Trusts are great for that. Creditor protection. If you put assets in trust and hold it for a child as an example, and that child might have creditors out there, well, those trust assets, if they're not owned by the child, they're owned by the trust or the trustee for the benefit of the beneficiary. Those are not reachable directly by a creditor. That's a pretty big deal. And if we're looking at it and saying, who's the biggest creditor in a lot of relationships? Well, it might be a divorcing spouse. And if we want to hold for the kid and maybe not for the fellow that she's going to marry, then potentially a trust is a good way of doing that. So We also look at long-term asset management. Large estates, or even folks who just want to benefit grandkids, might want to say, we want to put things in trust for the children and have them held until the grandchildren are a certain age, so that we know we're going to have assets here. I see this a lot with clients who are really want to, kind of put a net out there for the family and say, we always want to provide for health insurance, we always want to provide for education, and we want to help people get into a house. Those might be the three purposes, and we want to do it as long as we can because we want the kids to have that, we want the grandkids. We don't like these ages, so that kind of long-term asset management can be a benefit out of a trust as well. We can flip to the next one, please. Powers of attorney and healthcare directors. I talked about this earlier. Financial powers, appointing a person to manage finances. So this is typically thought in terms of folks who are quite a bit older, might be struggling a little bit with capacity issues or dementia, Alzheimer's. Really, really important that they have a power of attorney that names somebody who can do their banking, their financial work, make all those financial decisions in the event that they're unable to do it for themselves. The medical power, somebody to make the healthcare decisions. And both of these, the biggest decisions you make really is, do you want it effective immediately? So that when you sign the document, it says, here's the person. If they can't come to me, they can go to this person. Or do you want it to say only in the event of incapacity, which has to be determined by a physician, typically is how that's drafted in. I like people to think hard about that one. Effective immediately is very, very useful because then we don't have to go find a physician to try to write it up and say, yes, you don't have capacity. The downside is you're giving it to them right away, and you better trust them. Now, you better trust them anyway because you're naming them as a fiduciary for you. But that's really kind of that hinge point, that decision point. And then the healthcare directive, which I think is important to think about. It doesn't come up nearly as much as a power of attorney would. Now, powers of attorney can be very day-to-day. The healthcare directive is the form that says if you're in a permanently unconscious condition and the application of life-sustaining treatment would only prolong the process of dying, you request that it be withheld or withdrawn. And then you make the decision as to whether you want to have artificially provided food or water. So the form came into existence in Washington in the mid-90s after the Cruzan case wound through the courts in the late 80s and early 90s. I think it's good that people have the ability to put that out there and say, yes, this is what I want, because it does provide some clarity for family members at what's a very, very difficult time. So the good news is typically it doesn't happen that somebody's in that permanent unconscious, but it's nice if it does come up that's where we go, that you can make that decision. If we can go to the next one, please. Okay, I threatened that I was going to talk about taxes, and I meant it. I was trying to be casually cruel in the name of being honest. So the basics of the federal estate tax, that it's a flat 40% on an individual's taxable estate. Amounts left to a spouse qualify for the unlimited estate tax marital deduction. The theory there is we want to defer the tax. If you're holding it, spouse receives the funds, we're not going to owe it until the death of the second spouse. Each individual has an exempt amount before this 40% tax applies of $15 million. So a married couple can leave $30 million to the kid for federal estate tax. I'll come to Washington in a minute because it's not 15 here. $30 million to family members or entities other than charities free of federal estate tax. Over that 30 million, you start paying at the 40% rate. Now, one of the biggest benefits that Congress gave us a number of years ago was something called portability, which says to the extent that a spouse hasn't used her exemption amount, the remaining unused amount is going to pass on the death of the first spouse to the survivor. Again, it was just a backstop. If somebody hadn't done trust planning in a will, it was allowing kind of a do-over, or at least the ability to say, okay, the survivor is going to catch that unused amount. Great provision. So there's the federal estate tax, $15 million exemption. That came out of last year's tax law, got bumped up from $13.99 million, flat 15, indexed for inflation. So I hate to say, if I have to do this seminar next year, it's going to be 15 and something else that I'm going to have a hard time remembering. But we know right now, 15 million is our number. Let's flip to the next one. Federal gift tax. So you can't get around the estate tax just by giving it to family members and thinking it's not going to apply. Flat 40% on gifts made to an individual, same exemption amount. They used to call this back in the early 90s the unified credit amount because you could give during lifetime or leave it at death. So that was the idea, and it's unified again. For a while, it kind of went away, and then it was reunited. But the point is, you can give assets to somebody up to $15 million, and you do not owe any gift tax. Let me take a quick break here on gifting. So a lot of people think that you're limited to your annual exclusion amount, this $19,000 per person per donee. So each spouse to each child of 19,000 per year. And then over that, you're going to owe gift tax. Not true. You don't owe gift tax. You just have to file a gift tax return for the amounts over the annual number. And until you get over this 15 million number, there's no gift tax either. So just know that. I hear a lot of people say, I want to give the kids a couple $100,000, but I can't because of the gift tax. Not true. You can always give them more. You just might have to file a tax return along with it. So just food for thought on that. If we can flip to the next one, please. So like I said, this is unified. So if you make $5 million in gifts during lifetime and then you die, you still have a $10 million exempt amount that can be used on death. So that's kind of a good thing. I also put in here the GST tax. I promise you, this is a lunch meeting. Nobody needs to have that kind of queasiness during lunch. I'm not going to talk about generation skipping, but just know if you're trying to get more wealth down to grandkids, further descendants, there could be a second level of tax known as the generation skipping transfer tax. Same exemption amount, but once you get over it, the thought was that Congress had was, to the extent Congress thinks, the point is once you're over that, you will owe the gift tax and possibly this generation skipping transfer tax because you're trying to move wealth down a couple generations, and Congress wanted to catch you on that. So that was more than you needed to know at lunch. Let's go ahead and flip to the next one. Okay, here's the one that I get asked about all the time because people understand the 15 million shows up in the Wall Street Journal. How about Washington? How about Washington? Didn't we have a smaller exemption? Well, we do, 3 million. So the first 3 million, there's no Washington state estate tax, and that's indexed for inflation. It used to be 2 million. It was indexed for inflation, and then it stopped. So I had to tell people it was $2,193,000. They all thought I needed a hobby to think in numbers like that. But it's 3 million now. So for each spouse, they can leave 3 million to the next generation without having any Washington state estate tax. The shocker is the increase in the rates. The tax used to start at 10% and climb up to 20. Effective middle of last year, it goes from 10 up to 35. That's a big number. Now, anything that you pay to the state is deductible against the feds. So if you're over the 15 million on the federal side, at least your rate is going to start coming. It's not going to be 40.
James, somehow your microphone was muted. There you go.
You mean for the whole presentation, Mari?
No, no.
Oh, okay. Okay. Well, I'm sorry, I don't know when it muted. I hope we look at this, and again, $3 million per spouse is what to think about. The rates are high. Just recognize in larger estates, if you're over that 35% rate, it's a big number. So please do pay attention. Still have the marital deduction, which is good. Here's the big, and it's not portable here like it is for the feds, which is really disappointing. But there's no gift tax in Washington. There's no unified this or that. So the best solution for a lot of families to get around the Washington state estate tax is to start making gifts. So very tempting. Interesting. Why don't we have gifts? It's kind of nice that we don't. Let's just go with that. All right, let's flip to the next one. Here's a chart showing kind of what the brackets look like. And you'll see once you get up to these bigger numbers, like over 9 million, the tax on it's going to be almost $2 million. And then a rate of 35% on top of that. So these are real numbers. This is worth planning around, and people are thinking really hard what to do with this. It was a big lift when the legislature increased the rate this year. It did make a lot of people ask questions about, hey, how do we work around this? Let's go ahead and flip to the next one. This is just to kind of show the difference when the rate increase happened last year. For folks with smaller estates, it actually could have benefited them to go from this 2.193 exemption to 3 million. So for the smaller estates, I think this worked out. For the big estates, it's a big number. So again, this is why folks pay a lot of attention to the Washington state estate tax. Let's talk generally on the next slide about taxes for Washingtonians in general, because this is becoming a really, really big thing to think about. Again, since there's no gift tax, folks are definitely thinking about lifetime gifting. I put in here, pay attention to tax basis. So we have an excise tax on capital gains. I almost just said a capital gains tax, but Washington Supreme Court wouldn't like it if I said that. It's a tax that applies on an excise that applies on capital gains that I'll come to in a minute. We used to always encourage clients when I was early in my career, make gifts to kids in cash so that you do these things and the kids have the use of the full amount as opposed to giving them stock and then they have to pay a capital gain if they're going to need it. Well, because of the way the capital gains rates are, and if kids are fairly young or have fairly low incomes, there is or can be a bracket difference that encourages people to think about making gifts in stock or appreciated assets. All I can say is talk to your CPA, talk to your tax advisor. This is getting harder. In the past, it used to be easier. Now it's harder, like a lot of things. If we can flip to the next one, please. Step up in basis. So I get asked about this one a lot. People think they want to plan for a topic and they want to plan for the step up in basis. And I don't think you should, because you have to die. But just know when you do die, your assets, the tax basis that's used for calculating a capital gains tax, that it resets on death at the current fair market value. So if you have stock that you paid $10 for and it's worth $100 and you die, it's now taking a tax basis of 100 and it can be sold for 100 without any capital gains tax. So it's kind of a big deal. I put the example here on buying the house and what happens when it moves up that way. A really, really big deal. It does not apply to retirement assets, but things that are generally thought of as capital assets that you hold on to generally, it applies to. This last point here, this is one of the reasons we love Washington, a lot of community property states. You step up both halves of the community property on the first death. Very unusual. All the community property states have it and love it. And the idea truly is this example I have here, the stock with the low basis, it steps up. One spouse dies, you step up the whole thing. In non-community states, even things that are jointly held, you only step up the basis of the deceased spouse. So step up in basis, it's planning that we think about, that we talk about, but it's not something that you have to die to get it. So it's not like you can do a whole lot right now. Let's go ahead and step on the next one. All right. Here we go. Washington state capital gains tax. Folks are really unhappy about this one. So Washington levies a 7% tax on net long-term capital gains. This does not apply to real estate. Let's be clear about that. We already have our own real estate excise tax. This was intended to be looking at sales of securities. So it's getting at stocks, bonds, things that have appreciated that way. The legislature last year added an additional 2.9% once you're over $1 million. There's an exemption first of the 200. I think it's right around 270,000. So the extra 2.9 is not going to hit until you're at 1,270,000. But this is for individuals and certain pass-through entities. So certain irrevocable trusts, it doesn't apply. Certain corporate entities, it might not apply. And it applies to people who maintain a domicile in Washington. So the result of the capital gains excise tax, like I said, not an income tax, is that folks are looking at where should they live in terms of maintaining a domicile, and how should they be holding on to different assets to really kind of find their state of grace. Where are they going to find a place where the tax setup is more to their liking? If we can flip to the next one, please. So planning in the Washington state tax. So the big one that we talk about with people all the time is the first one, residency. Then philanthropy, and I will come to that in a minute. Reckless spending, always a good choice, right? If you want to spend a whole bunch of money, once the estate's below the exemptions, you won't owe any tax. That's tongue-in-cheek. We're not advocating that one. And then making gifts. Knowing Washington doesn't have a gift tax, that's a big reason that folks are looking at making bigger and bigger gifts. And yes, I put a piece of clip art that is over 30 years old on the screen with the duck. So if we can flip to the next one, please. Residency. So Washington state estate tax is based on where did the decedent intend to reside when she died? Well, can't ask her. But you look at the facts and circumstances of maintaining a residence and where did you live and all those types of things to figure out where your intent to reside was. Moving out of Washington is difficult. I get asked this a lot with people who think they want to move to one of the states that doesn't have either a separate capital gains or income tax at all, or a state estate tax. Folks tend to lean on looking at Nevada out here in the West, or Wyoming if they like to ski. Those are two of the big places folks are asking about with taxes, but you have to move. You have to go there. You cannot just get a P.O. box in Incline Village, Nevada, and think that's good enough. That is not changing your residency. Owning real estate in Washington, even for non-residents, causes or may cause Washington state estate tax if it's held in the name of the decedent. There's an apportionment that Washington does if you're here for part a year or part of the estate holds the estate. So that one can be rather tricky. But the whole point here is moving out is not simple. And for a lot of people, kids, grandkids, all that kind of stuff, not easy. All right, philanthropy. This one I really want people to pay attention to. Making gifts to charity during lifetime will reduce the estate size subject to tax. This is the one I should have put up on the first page and pretty much every page. The current gifts, I really want people to think about this. When you're making your United Way gift this year, and please do, look at appreciated assets. Look at things like your stock portfolio. The market's done really, really well in recent years. And all of that appreciation would be subject to federal capital gains tax, and state, possibly capital gains tax, depending on the exemption. If you give that directly, you still get the deduction generally for the fair market value. And when the charity sells, they don't pay the tax on it. So appreciated stock, that's how you should do. First of all, you should do gifting, and second, it ought to be an appreciated stock. For folks who are taking distributions from a retirement plan and they're over 70 and a half, they should be looking at qualified charitable distributions if they don't need that full distribution. So those are kind of the two current gifting things we like to look at. And then at death for philanthropy, the most common, the most, I think, beneficial way of doing it is looking at retirement plan assets, not Roth, but non-Roth assets that still have all the income tax bound up in them. Those are great to leave to charity because those are going to go to the charity. And when they cash that out, they're not going to have to pay the income tax on it. So taxes, things to think about. Philanthropy ought to be a big part of how folks are looking at how they're structuring an estate. Let's talk a little bit about how to give to charity, different ways. Outright gifts, the pro and the con is obvious. Immediate to the charity, you get the deduction. The con is loss of control. Never had a client who was a control freak. Sarcasm. Of course they are. So letting go of that control is hard for people, and it may not provide a benefit to their heirs, so they're reluctant to do it. I still think that should be the starting point for every estate plan. A structured giving program, whether it's a pledge, whether it's a trust, or something that just says, I'm going to keep giving over time, really powerful, really helps the charity understand what their cash flow is going to look like. Now, a lot of these are irrevocable. So irrevocable means I can't change it. Revocable, change. Irrevocable, can't. So that's a con, but it's also, in my mind, a pro because it shows a commitment and it makes it easier for the charity. And then how about testamentary gifts? Many, many people put a provision in a will or a trust that leaves a portion of the estate by percentage or a dollar amount to a charity. Allows you to have control of it during your lifetime and know that it's going to go somewhere on death, and likely leads to an estate tax charitable deduction. Likely because there might be hiccups depending on the type of charity or the size of the estate. But generally, that's going to lead to a deduction on the estate tax side, which I think is great. The biggest con, there's no impact during the donor's life. Some charities will name something after you or whatever, even in an expectancy without getting it. But really love to see people doing these during lifetime. Still, lots of different ways to do it. Let's go ahead and flip to the next one. This is, again, I'm going to stress appreciated assets. No capital gains to the donor, charitable deduction, and the charity sells and they get all the benefit. Such a great way to make gifts. So encourage people to do it. United Way is set up to receive stock if you want to send stock over, so have at it. All right, let's flip to the next one. Non-charitable gifts, now versus later. So this is giving to the family members. Most people want to see their kids get the benefit. Kind of shows up in the Die with Zero book, where the author talks about making gifts when people can really use the money and you can see them get the benefit out of it. Something certainly to think about, where instead of just leaving it at death, which we don't know when that's going to happen or what the needs are going to be, or hopefully if all of us live a good long life, that's going to mean that kids might not get it until they're in like their 60s. Well, think hard about that one, whether you want some gifting now or some at death or a combination of the two. Also really great for saving for college or other unanticipated expenses. Gifts to minors, want to think about how we title those. Outright, tough, because if you have a minor child owning things outright, it can be difficult to manage. We want to look at things like trusts, custodial accounts like a UTMA, 529 plans, or even Washington's account. Let's flip to the next, please. I think I'm running out of time too, so I'll try to be quick. Legal issues to consider on gifting. Gift taxes if you're over the $15 million number. If we look at each year's gifting, what you can do, and then specific or direct payments. If you have a child in college and you want to write the check directly to the college or have grandma and grandpa do that, great thing to do, because that's not even considered a gift. If it goes from them to, say, the University of Washington directly, not treated as a gift, they don't worry about this kind of stuff. Let's go ahead and flip to the next one. How to move forward. What should you do? So before you meet with the lawyer, review what you have if you've done something. Review your beneficiary designations. Know what that 401k through work says or that IRA and where it's going to go. And then look at how things are titled. Are they joint with right of survivorship? Because like we talked about, that overrides or steps on top of a will, because it does it by operation of what that agreement says. And then community property, wanting to know who owns what. It's important when you meet with the lawyer to know what you own and how it's titled, what you owe if you have debt that's out there. I think those things are actually really, really important. And that's kind of where I would want people to start before they go see a lawyer. Let's go ahead and flip to the next one. So let me pull it all together. Best way to do this, take an inventory of what you have, assets, liabilities, build out that team of people, probably have a CPA already, which is good, and then have a lawyer who's going to do this. Figure out, even before you go in, who you would like to benefit from your estate during lifetime and at death, and then think about who these fiduciaries, personal representative of the estate, trustee of any trust, who are the people that you're going to rely on. And a lot of times I've done sessions before where we talk about how do you figure that one out? How do you know who you'd want to rely on? Does it always have to be the firstborn child? Certainly not. Very traditional to do that, but it doesn't have to be. Should it be all the kids together when you have 3 or 4 children? That's tough. Maybe not on making some of these decisions, but work through those in your mind. That's the hardest part in the process, is knowing who's going to do what. And it's the first thing the lawyer's going to ask you when you go in. Hey, who would serve in these roles if you were incapacitated or when you pass away? So that's the pulling it together. What do you own? Who are you going to talk to? Who's going to receive assets? And then who's going to be that fiduciary to help them receive them? Let's flip together this little checklist here toward the end. So look at what the assets might look like, all the things that are here. Think about things, and I put on here jewelry, artwork, things like that. It's worth considering if those should go to somebody directly. Those generally don't have to be in a will. You can do a fairly simple tangible personal property list that says we leave, the artwork to this child, or we leave the jewelry to another. You don't necessarily have to update your will for that tangible things you can touch, personal property. So not real estate, not stocks and bonds or accounts or whatever. Those things I think are pretty important. Look at the liabilities that you have that are out there, and then figure out some of these other pieces of information. The digital assets, information and passwords, all that kind of stuff, those are tough. Write them down, have a backup way of making sure that they're available. Powers of attorney and things have been updated nicely over the years to be more specific in terms of who has access or control, but think about who you'd want to do that. Let's flip to the next one, please. You've signed the will. Now what do you do? Keep it in a secure place. Well, people used to always put them in their safe deposit box. The only problem with that is if it's the original will and it's in the box, you can't open the probate without the original. And if you don't have the key, you can't get into the box. So it's kind of the cat chasing its tail problem. So probably not the original in the safe deposit box. Maybe that stays with the attorney. Copy for your fiduciaries, maybe. But again, if the kids are listed, do you want to be sharing that information during lifetime? Maybe you do. In a lot of families, I think that's a great thing to do. But if you ever want to change, then do you have to retrieve them or just tell the kids we've made a change? Just think carefully about it. How often should you update? And anything on this slide, really, these could be full, deep discussions. I just want to put some of these out there. Every few years is typical. The bigger one is when the family, the wealth, or the goals change. So in a lot of families, they don't update the will for 20 years. And that's okay, because none of these things have really changed. They know who they want as the personal representative. They know what the shares should be to any of the kids. Those are all good. For a while, people kept trying to chase the federal estate tax around when it was changing so much in the early 2000s and early 2010s, and wanted to feel like they had to keep updating. That's usually not the most important reason. And if it is, then I'd question the attorney who's drafted the document. Did they not use a formula that allowed you to soak up the exemption amounts properly? Again, these things, your family, your wealth, and your goals are really the big ones. And then truly make this list of online accounts. Make sure spouse knows how to access. Those are hard. That will slow down a probate. That will make it difficult to get this type of information when you need it. If you can flip one more. Discuss your plan. Work with a team, lawyer, CPA, financial advisor. Think about whether you want to talk to your family about it. Some people do, some don't. It's okay. Whatever the family wants to do is okay. Just recognize that if it's going to be a big surprise, or if there's going to be a problem, you don't necessarily want to put that out there so that it's completely unannounced to somebody, and then they don't want to serve, and then that's not exactly what you might have wanted. And if you're naming like somebody outside the family, you don't want to ruin the friendship, even if you're deceased, and say, here's who's supposed to do it, and then it's a big mess. So maybe you do want to think with them a little bit. Fiduciaries, especially powers of attorney, at some point they probably ought to know this. That's kind of what I would think about as well. So that's pretty much all that I have. And I'm sorry I went over a little bit, but I'm happy to take questions, and I'll toss it back to you guys for any questions. Ross, that's very kind of you. Thank you.
Thank you, James. I want to ask that the United Way of King County mute themselves. There's an open echo. There we go. That was amazing. Thank you so much, James. I
Thank you.
want to remind folks that we're going to have a survey after this, and we'd love to have you fill it out. And we have a little incentive with 2 tickets to Cirque du Soleil or 2 tickets to see author James McBride at the upcoming Seattle Arts and Lectures event. You'll be entered into a drawing for that. And I also wanted to remind folks that this presentation will be emailed to all participants, but we do have we have quite a few questions here in the Q&A section. Um, so I am going to read them
You
out
just want
to
to read those
you.
to me?
Yeah.
Okay, let's do it that way. Yep, then I
Can
won't click through.
can property, so houses, be put into living trust if they have a mortgage, or will the bank typically object?
Ooh, and I worked for a bank, but no, generally banks don't object to it. So I made the point about a living trust is not providing any tax benefit. It's also not providing any creditor protection. So if you deed your house over to a trust, I do encourage people, let the bank know that you're doing it. But
Hmm.
most deeds of trust allow you to do it to a living trust because you're still fully liable on the debt. So it's not wiping away the debt. In the old days, long ago in my early years of practice, it was a little trickier. We had to get a written notification. Now, no, most people just go ahead and deed it over. Do recognize if you go to refi, you're probably going to have to deed it back out to yourself from the living trust in order to do a refinance because the deed of trust will have to take your name on it. But generally, no, putting it into the trust is no problem. It doesn't trigger any kind of due on sale clause.
Nice. Okay. Next question is, can you talk more about the tax implications of a trust? This person seems to recall that taxes can be higher for trusts. Is that true?
Oh wow. This is about income taxes. First of all, for the group here, because there are lots of different taxes that could apply to a trust, but this one is dealing with income taxes. So if you create a trust for somebody else, the trust can oftentimes be taxable to the grantor. We call it a grantor trust. Tax code was very specific to use terms that kind of make sense here. Those are just taxable back to the grantor. So there's no problem. That's just still going to show up on your 1040 for any gains and losses or anything else. But if you create a trust that is not a grantor trust, so typically an irrevocable trust for somebody else, where you as the grantor don't have any of the powers that cause it to be taxed back to you, then it's going to have to pay its own taxes. And yes, those generally are, they're not a higher rate, but they climb through the rate brackets much more quickly.
Hmm.
So for a married couple, you don't hit the top 37% bracket until about $600,000 in income. A trust hits it at $13,000 in income.
Hmm.
Now, when a
Wow.
trust has income, to the extent it distributes it out to a beneficiary, so a trust has 100,000 in income and it distributes the 100,000 out to the beneficiary, it actually gets to take a deduction on its tax return. Generally, I don't mean to step on the CPAs out there. Generally, going to take a deduction for that 100,000 that went to the beneficiary, called distributable net income, and now the beneficiary pays tax on it. So if you really need a don't do this. Income taxation of trusts and estates is actually remarkably complicated, and it feels like it floats as to who's responsible for the tax, whether it's the trust pays it itself because it obtains the assets, beneficiaries because things came out and now they have to put it on their 1040. In general, the questioner is absolutely correct. Trusts, if they're retaining assets, hit that top tax bracket about $13,000 income.
Hmm. Okay, so this next question says, if I don't care about specifying use of the money by the recipient, so children at certain ages or specific uses, is there any reason to use a trust, especially in Washington where probate is easy?
Um, okay, how about privacy? I think I threw this
Mm,
one up pretty early. Probate, because it's a court proceeding, is fairly public. Now, it's not like, again, I keep talking about the old days. We used to have to publish a full inventory of what the person owned when they died. And what I mean by publish is it had to be entered in the court file as a court pleading that said, here's everything that the person owned and here's the value. Well, we don't have to do that anymore. Personal representative just has to say, yes, I took an inventory. But it's still a public proceeding. You can still, it's not quite like playing Zillow and clicking on your neighbor's house to figure out how much it's worth, but you can look at a court file and you can see some of the documents in terms of what the will says. So there's a reason for wanting to do a trust, is that the will is public when someone dies, is because
mm,
it has to be put into the court. So even if you don't have these other reasons, and probate is simple here, I really believe that. That is not the
mhm.
sole driver of saying I need to do a living trust because it's really expensive. It's very expensive in California. It's becoming more expensive in Oregon. Idaho, not so bad. East Coast states, pretty bad. So, but just knowing that it's still, you can do a lot of this yourself, retitling during lifetime, or at least on the death of the first spouse. That's a great time to be funding a lot of these things, because to figure out everything that you own, it's best when you get the mail and you know what the
Mhm.
accounts look like. So if it's coming to the same house, it's kind of easy to figure it out, even if we haven't funded our living trust. If the kids are going to have to serve as a trustee, it can be a little harder if they don't have a list of assets. So the question was, though, could I just put it all in a will? You could. Privacy, I think, is a nice thing to have. Having it contained in one thing, if you've got husband and wife, to have kind of all in one document is kind of nice. If you're going to hold longer term, but I think here the thought was, now you're going to give it to them right away. I'm not going to say you have to do a living trust. I'm just not. And in fact, for a lot of people who want things to the kids outright, some combination of having a will, maybe putting payable on death or transfer on death on the accounts that just
Mm-hmm.
do zip to the kids without a probate, or joint tenancy if you're wanting to do it that way. Those are not bad options. So,
Mm-hmm.
but they need to be done intentionally. If you're going to do that, make sure you know which assets and that you caught everything. I
Okay.
talk way too much, but that's
No, no.
long
This
answer to a short question.
so interesting. This is not a short question, but it might be our last because we're almost done. What should my spouse and I expect to pay an attorney or other advisor for fairly basic estate plan? Like, is it a flat fee? And can you talk about using an attorney versus someone who's not an attorney?
Okay, so the what does an attorney charge? And even in my current role in wealth management, I get the question all the time. And I practiced law for a long time, so I'll give you the lawyer's answer because it's still the same. It depends. And a lot of it depends on the size of the estate, the complexity. Most lawyers are still billing by the hour for this type of work. And to be fair to them, they probably ought to be, because really simple estates, everything's just going to go by the will. It's really straightforward. It takes a lot less time to do that than it does if you're going to have multiple family business interests, real estate LLCs, liabilities, debt, personal guarantees. That's just more complicated. So
Mm-hmm.
what should it cost? It's really hard to, I'm really sorry. It's hard to say. I see fairly simple estates between $3,000 and $5,000 for husband and wife. Don't hold me to that. Maybe it's less, maybe it's, I don't know. But it's a lot of times it's in that range. Some lawyers will quote a flat fee and say, we'll do the whole thing for this. But then be careful, make sure you know what's included. Maybe they're not helping with the deed to the house to fund the living trust. Maybe they're not looking at beneficiary designations. Maybe it doesn't apply if one spouse is not a citizen. So
Mm-hmm.
there are lots of reasons why complexity really will drive this. Part of the question, and I'm sorry if I missed part of it, was should you have a lawyer do this? I think generally yes. You don't have to. I mean, you can use LegalZoom, you can use Trust and Will. I think they advertise a bunch too. Get the documents and look at them. I encourage people who do that to understand. First of all, you're going to have a hard time bringing that to a lawyer and asking them to review it. I used to get that when I was in law practice. I did it myself. Would you review these? Generally, no, because the lawyer doesn't want to take the responsibility for someone else's documents. But the things to watch for, and I'll try to be quick on this one in those documents because I've seen a bunch of them, are they properly executed under Washington law? 50 states, everybody has a little bit different requirement. Wills do not have to be notarized in Washington to be valid. They need two witnesses. So you can sign a will and just have two generally unrelated people who are not going to receive a portion of the estate. So uninterested witnesses are sufficient that we need for a will. You generally want a will to have the decedent or the testator or testatrix, so the person who's making the will. You want her signature, then you want the witnesses to acknowledge it. And then a lot of times the lawyer will encourage you to attach what's called a self-proving affidavit or a statement where they also sign again. Sometimes they do sign with a notary. So just be careful with execution on things like wills. Powers of attorney, same way. I usually recommend they're always notarized, especially a financial one that you might have to file in a court. Like, give a quick plug for notaries or why you do a notary. Notaries are usually required for things that have to be filed with a court or in the filing system, like for the county recorder's office. So people would talk about getting a notarized letter. I always wondered what that was all about. If you're not going to file it, you probably don't need a notary. But if you're going to file something, you probably need it. So powers of attorney here, we usually do that. Trust, we usually want a notary. Wills don't require, but a lot of people do. And the healthcare directive is the two witness requirement. So be aware of the execution things. And then the other thing that I used to see with those types of wills is people would forget the residuary clause. They would say, I give 100,000 to this charity, 250 to this child, $30,000 to this friend. And then they'd sign it. Well, if they had other assets, where do those go? Well, now we're
Mm-hmm.
back to dying without a will. We look at state law, and again, spouses, children, parents, and then up and down the family tree. So just be really, really careful. Residuary and execution. Those are the things if you're going to do. You don't have to have a lawyer. Did I miss part of the question, Anna? I thought there were three, and I think I did the first and the last. Was there a middle one too? I don't
I
remember.
was just noting somebody reminded me this goes to 1:30, so we're not in as big of a hurry as I thought because we've got
Okay.
several more questions to get to. Um, the question was, I think you answered it. It was, what can you expect to pay? Is there a flat fee? And then can you talk about using an attorney versus someone who's not an attorney?
Is there a flat fee? I think I did answer that. More
Hmm.
and more lawyers are doing that because clients are just uncomfortable having an open checkbook with the lawyer. But I think it's important when you first meet with them, get a sense. Is there a range? What types of things? That's when you prepare to meet with an attorney, the fee question ought to be pretty upfront and determined at the first meeting. Hey, are you hourly? What's your rate? Is there a way to do this on a flat fee? If so, what's included or what's not? And just know you want to have a relationship with this person, and they're not doing this for free. So you should
That's
be
right.
able to talk with them about it. And most lawyers are okay having that discussion. Hey, this is what I charge, and this is why, and this is how we're do that. And I
Yep.
think most attorneys are okay with that.
Awesome. Okay. We have 12 questions and we've gotten through four-ish. So, what happens to the basis for traditional IRAs, knowing that the basis in brokerage accounts is stepped up? Is the entire value still considered as regular income, or does that change upon death?
So there's no step up on an IRA. So we don't get that one. It's not treated as a capital asset. So there's no step up on the IRA assets. So if the first spouse dies and it's a traditional IRA, so everything went in there on a tax deferred basis, when the
Hmm.
money starts coming out, it's all taxable and it's all ordinary income.
Sweet. Okay.
If it's a
Uh,
Roth, no, but that's after tax at that point. But still no step up on that one either.
okay. In terms of life events, what types of life events should be considered when making changes to my estate plan?
Okay, that's a terrific question. I love the way the person framed it. So save that one, send that one to me. That's delightful. Most life events actually should have at least a thought going into your mind. Kids go to college, maybe they ought to do a power of attorney because they ought to name mom and dad so that if they're incapacitated, mom and dad can consent to treatment because they're adults. Kids are going to get married. Should they think about a prenuptial agreement? I know you said estate plan, but some of these things to me fit in as part of an estate plan. Cohabitation agreement for people who are living together but not married, as to how they, how are they allocating expenses. Not as important for a lot of people, but it could be certainly something to think about. The big life events are typically birth of a child, where you want to make sure you've got a will that names a guardian for the kids. Probably want to hold things in trust because they're just going to be little people, and we want to make sure we're holding longer. Um, I used to see a lot when I was in law practice that as soon as a grandchild showed up, that was the moment to rush into the lawyer. It always made me wonder, did they like the grandkids better than the kids? Maybe. But the idea was they might want to set up something to help with college for the grandkids. And it seems like a great opportunity to do that. And I think a lot of folks, if they've already done a will, they like to come back in and revise for that. So those are the obvious life events. Leaving a job, I used to always tell people, look at your benefits, look at what you had through work, be very aware of what that is. If there's elections you have to make, if you had company stock or RSUs, those are things to think about. Kind of still part of an estate plan discussion because it's still assets that you own. I think other life events that are related to that, divorce, certainly a good time to update documents because you want to make sure that you're naming the proper people. Now, do recognize when a decree is entered in a divorce that the spouse's name is generally knocked out of the documents because the state law seems to believe you wouldn't want that unless you execute the documents after. But the decree itself usually removes the spouse from a lot of the documents. Other life events, so it's birth, it's job change. I do like to think about folks who are looking when one spouse dies. That's a great time to be thinking about making gifts because you've got to step up on a lot of other assets. So there's real tax planning that's done on the first death. Death of a parent. So that type of life event, you're about to receive an inheritance. We're thinking about how you want that to work out, especially if you're going to receive something jointly held with a sibling. Yeah, be aware of that one. Real property located in another state that you don't visit very often. May want to talk to a lawyer about how should you own title to that. Jointly held, should there be an LLC? There's so many, and I'm sorry, most people think of life events as birth and death,
Right.
maybe a wedding. Okay, so
Yep.
those are there. But I think of a lot of other things as potential life events as well. The job change one, I used to always advise clients as well. That's not necessarily the time to make big gifts because you as a retiree might need to think about what your needs are going to be and what you want to accomplish before you start handing off money. But those are the big life events that I can come up with. If anybody has others, feel free to ask.
Okay. This is another sort of technical question. When considering qualified, so retirement, IRA, Roth accounts to designate to charities, is it better to make the successors for traditional IRAs versus Roth? So, in other words, is it better to give Roths to beneficiaries?
It is. How about that? That was quick.
That was
Yes,
good.
because There's tax that's lodged inside the traditional or the qualified assets. And with the Secure 2.0 law that says you've got to bring them out in 10 years, we don't get the big deferral that we used to get. So in the old days, it made a lot of sense. I've always thought it makes sense to give them to charity with the tax lowered into it. But in the old days, people would say, but I want the kids to be able to stretch it for a very, very long time with more and more tax deferral. That was
Hmm.
true. There was a big benefit to that. I think that crossed over with the 10-year rule under the Secure Act. That's
Okay.
10's not for spouses, but this is in terms of kids or other people named that are non-spouse beneficiaries. It's all got to come out in the 10-year period. So that to me makes it even more relevant for saying that should be going to a charity. Now a Roth, you don't have the income tax inside it. So that for a lot of people is becoming a real primary asset to point at the kids. I think that makes a lot of sense.
Nice. This is a fun one. What's the worst failure you've seen in an estate plan that you can
Well,
divulge?
all of my clients are delightful people. None of them are a
Yes.
failure. Their mothers all love them, so it's all good. I would say the biggest failures really related to people trying to do things for other people instead of what was the right thing for them when they did the plan. So they would name their firstborn as the trustee of a trust, and even though that trust would benefit the other siblings, and the firstborn wasn't very good with money, didn't really get along with the other siblings, and now had to be a fiduciary for the other siblings. That's a train wreck. You can see that one. That's pretty obvious. That was in many cases the biggest fail. And again, most of the, and I've got a couple others, most of these are not tax fails.
Mm,
It's not as though somebody tried to leave money to, way, way, way downstream and they didn't think about taxes. Well, some of those things can actually be fixed after death. There is post-mortem planning we can sometimes do, but it's usually the family issues that come up. It's naming the child who might live in Bora Bora to be your healthcare power, and they're not very reachable. That might have been a
hmm
bad example. I think they have good cell service, but finding a place that doesn't, and then it's very hard to get someone to consent to treatment. The other really big fails that I've seen is way overcomplicating the estate. The people who wanted each and every asset either owned by an LLC or owned by a
mm,
separate type of trust, figuring they would all fit together, and then they didn't. And then the family had to clean up everything when somebody died. And then
hmm
for business owners, the biggest fail for business owners is they create their company, they do a buy-sell agreement with their partner when they first set it up, and then they forget about the buy-sell agreement. And then 20 years later, the company's wildly successful, and the buy-sell agreement either gives everything to the other partner and leaves out the family, or
hmm
creates a ridiculously low value for what the ownership of the company is, which also then reduces the value of the family. So the biggest fails, though, are typically you're appointing the wrong person as the fiduciary. You are giving assets to somebody you didn't really want to give it to them, but you're creating conflict. I mean, I've joked for years with people that clients would come in and say, no trust babies. I don't want any trust babies. And the answer from the lawyer should always be, then I hope you raised them right. Because the document's not going to make them that way. It may restrict their access or it may make them
hmm
feel like they're more dependent on it. But my experience was not that dependency was as big a problem as the relationship issues that underlie. Sorry, that was a sermon, Anna, but that's kind of how I feel about it.
I love it. Okay, so the next couple questions are about navigating this process while living in poverty. So one is the Washington probate process seems to penalize folks who live in poverty. Is there any way to do that for free?
The best, well, I mean, there are legal aid societies who will do wills. You can go to the King County Bar referral service and find attorneys who will do pro bono will drafting. And again, wills, yes. And I always say wills. I'm sorry, because I started the presentation and said, don't talk that way. Powers of attorney are the most important things, especially for indigent people. They should be ready to
Hmm
name somebody, because if you don't, you opt yourself into a court proceeding as to who should
hmm
make medical decisions or financial decisions. Those forms are fairly easy. Washington State Medical Association used to have one on their website that was a healthcare power of attorney, like WSMA.org. I'm not sure it's there, so I probably shouldn't have said that. But they used to have one. You could just download the form, fill out the name of who you wanted to be your decision maker, sign it, and you were pretty well good to go. So for folks who are low income and indigent, look to the bar referral services. And I'd start with King County because that's where we're sitting. Washington State Bar Association has one as well, for lawyers who will do a pro bono. In the absence of wanting a pro bono, look first to these powers of attorney because those are typically the most important ones. Um, that's where I would start.
Okay. And I think the next question, actually, I think you just mostly answered it. She was just curious if there was any legislation that protects or helps someone going through this process, because there are things like court fees and transportation costs that can be a burden to the family. Um,
There are, I mean, the legal aid societies try to help with a lot of this. It's not perfect. I mean, I
mhm.
think we do pretty well with it in Washington compared to a lot of other states, but it's any court process penalizes people who have a hard time paying.
Yeah.
It's a sad but true fact of American life. And the fees are what they are, and they keep going up because the
Mhm.
legislature typically wants to look at and says if you're using the courts, you ought to pay for them. But they are
Mhm.
creating quite a barrier for people who need to have access for them. Again, the legal aid societies are pretty good and are pretty good at trying to step in and help with these things, but it's not perfect.
Another example, it can be really, really expensive to live in poverty.
Yes,
Um,
it,
okay, so this is a question about capital gain. Okay, no, it's now that capital gains apply to precious metals. What's the best way to give those to your children? Inheritance, gifts?
That's a great question. It's truly like any other asset. If you want them to have it now, a lot of times precious metals can be hard for people to sell because you have to typically go to a precious metals dealer. It's not, you can't sit at the computer and sell the stock by pushing a button. And a lot of times there's a kind of a spread between what the what the spot price might be and what the store is willing to pay you for it. So recognize that that's there. I still tend to think this is my opinion, and it's not just the tax opinion. I think it's better a lot of times to be giving cash and letting the owner sell it and pay the capital gains tax. If there is a sense that you're giving it to a person who's going to be under, say, the Washington 270 limit, then yes, there's a reason maybe to make the gift and let them do it. But precious metals, because they're not necessarily certificated or documented, and you're making a gift of, say, gold coins or silver bars, whatever it is, there's no transfer paper that goes with it. I mean, do recognize it's a gift of value. So it should still be looking at the amounts you can give without the gift tax applying or the annual exclusion from gifts. It's still there. I know people will say, well, but no one knows. Well, but yeah, you do. And the law says you're supposed to report it if you sell those types of things or make a gift. So even with precious metals, just be aware that if you sell them, somebody's going to have the capital gains tax, whether it's going to be the recipient or whether it's the donor selling and giving cash. I hope that answered that.
There's these are a couple questions from the chat. Thank you, Carrie, for putting these in the Q&A. Um, this person is wondering if there are options for a personal rep other than a family or friend and how to evaluate a non-family member.
That's a great question. First of all, you start with trust companies like the one I work for. We serve as personal representative or trustee of a trust. Most of the banks in town do that. They typically, if they have a trust charter, either from the state of Washington or federal charter, they can serve as a personal rep or trustee. A lot of people, when they draft a document, will say they want a corporate trustee and have a family member name that one. That's a flexible way to do it if you don't have a relationship with one of us. So that's kind of a good
Mm-hmm.
way to do it. There are professional guardians or professional PRs that can do it. So they're individuals who are listed, and it's a little hard to want to refer to somebody if they're not licensed with the Department of Financial Institutions. So it's a little tricky if you find somebody who holds themselves out. Ask them the question, hey, are you registered or licensed anywhere to do this? Or are you just a guy? Because you can always appoint just a guy. You can appoint a friend. You can appoint your lawyer if the lawyer wants to do it, or CPA. Most financial advisors cannot do it. It's generally a conflict with most individuals at banks and brokers that they cannot serve as a personal representative of an estate. But especially the PR job can be a whole bunch of work at the front end to try to gather all the assets. So think hard about that. If it's a family member who knows where things are, they're a great choice. If it's a family member who's organized, they might be a great choice. Otherwise, I do think the banks and the trustee or the professional trust companies are pretty good choices. But it can be anybody, so long as, again, over 18, no felony or fraud conviction. Um, it's a lot of work, though. I mean, if you appoint a friend, don't ruin the friendship. Try to make it so
Right.
that it's somebody that's going to like. So, yeah, and I say ruin the friendship. That's not just a Taylor Swift quote. That's truly what I meant by you don't ruin the friendship and mess it up.
The same person was wondering, some banks help clients, their criteria is that assets need to be greater than $5 million. Do you have, what criteria does your bank use?
Great question. So I'm with private wealth management at US Bank. Our minimums are around that, usually over 3 million.
Okay.
And then we do consult and advise people on all these types of things. A lot of our competitors are doing the same thing. Where the minimums are, it's hard to know. Ask them. and they'll tell you. I mean, we work with a lot of people who are under that, not in my division, but in other parts of the bank. And then those folks can also have access to us as a successor trustee or a personal representative. So it really kind of depends on the institution, what the numbers look like. The reason that most of us have a limit or at least a minimum that we're using to work with is we have to limit the number of clients that we have in part. And the services that we have are directed at folks with increasing levels of complexity in their lives. I'm not trying to be mean. It's just you can't do it for everybody because we don't have enough people here. There are, kind of folks to look at for, again, the professional trustees. Ask the lawyers. If you're working with a lawyer on this, they're going to tell you, here are some of the ones in King County that you can work with. Sometimes the courts are also appointing people for folks who need a court-appointed guardian, or if there's nobody listed in a will and they have to appoint somebody, they do maintain a list of some of the other fiduciaries in the Seattle area.
Excellent. I think we've answered most of the questions in the chat. We do still have 10 minutes left if anybody wants to throw anything in. One thing we've been chatting about on the side amongst my colleagues is that I think there's an opportunity for us to do a blog post about some of the challenges with navigating estate planning and dealing with assets, and navigating that when you don't have the resources. And I think we can, put out some more information afterwards. There's some real specific questions in here about that's not what you're here necessarily your background to answer. And so we can do that separately in a blog post and do a little bit of research to help folks navigate that.
I think that's helpful. I think another big area that we didn't touch on, and I freely admit I'm not a big expert in this area, is planning for Medicaid or qualifying
Mm,
for state benefits. A lot of
mhm,
people do as part of an estate plan. If a child, as an example, is
mhm,
receiving some type of state assistance, they want to be very, very careful when they put their own estate plan together not to disqualify the child from receiving the benefits. A good example would be a child with a disability or an incapacity who is getting a nice job training benefit or has a job that they only got because they were in a state program. I think that that's really important to think about and to work with lawyers who are very comfortable. People use
mhm,
terms like special needs trusts, where they're wanting to help provide for a child while not disqualifying them from state benefits. Those are really, really important. So when you first go to the lawyer and they're asking about any of these types of things, it's something to think about, because those special
mhm,
needs trusts need to be drafted in such a way. Not though I said trust can be flexible, they can do all these things. If somebody is a beneficiary of a very flexible trust, you could easily disqualify them from receiving any of the different state benefits that they could qualify for. So that's kind of a big one that I didn't really talk about in terms of from a planning standpoint, but it's worth bringing up with
mhm.
an attorney.
We have another question here. That's a little bit about that. Is there a good age or time for someone to start considering estate planning?
Uh, that is a really good question. Okay, so I think depending on what we consider estate planning, going back to that early slide, powers of attorney, I really think when kids go off to college, they should be doing those. So that would be
Hmm.
the toe in the water in terms of looking at a legal document that they're going to sign, that healthcare power, that financial power. I think those are a good thing to start with. Generally, think about estate planning also when you have a full-time job and you're getting life insurance through work, or you're putting money into a 401k. Some of those things I think are points where you should think about it. I have a lot of clients whose kids were in their late 20s and parents were fairly wealthy and everything, and they didn't do things, and that's okay. But they should be thinking about, if you're single and maybe you want your bank account to go to a charity, do a payable on death to the United Way, as
Hmm.
opposed to knowing that if you don't do anything and you die and you have no will and you have no kids or spouse, it goes to your parents. Maybe your parents don't really need it or whatever, and you didn't want that. You wanted to go to
Hmm.
United Way. So those are things with estate planning. If the question was, when should you do a will? I will say, if you have a child, you should do a will. No exceptions. You should have a
Yep.
will that names a guardian. So once we're talking about money and everything else, then maybe there's some flexibility in there. But that one to
Hmm.
me is kind of the do not pass go one.
Been on my list for 16 years. I need to get on
But
that. This is good.
but you didn't need it. You didn't die. Right.
That's
So
right.
no
Knock
one
on
should
wood.
scold you for saying, oh,
That's
you
right.
don't have a will. No, no, no. You did. Look, it's not something that we should do it because we have things we want to do, and
Yeah.
that all too well. My
Yep.
favorite line I like to quote, all too well. So I
That's
think
right.
it's important that you do it when you can, and that you look at these other pieces of an estate plan. Again, powers of attorney, account titling, all that kind of stuff.
Hmm. We do have one question here. It's not in the Q&A, but I think it's worth asking. So the IRS requires taxes to be filed for a person, even if they're deceased. How can that be placed in estate planning? I
Oh, you
think the
mean their last
question is,
1040? Their final 1040, their
yep,
last income tax
yep.
return?
Who files
You don't need to
those?
work. The personal representative signs the return. So they're signing everything else. They're the fiduciary for the estate. The
Hmm.
PR is going to sign the final tax return, collecting the W-2, the 1099s, whatever it is, doing the best they can to file that final 1040, and the personal representative signs. And then they have to attach the letters testamentary showing they were properly appointed. I hope that answers that. That's what we're
Yeah,
looking at. So don't
yeah,
plan for that one because that's you're dead. Somebody else will take care of it. Don't worry about it. Just do the will. The will says who it is, and they'll take care of it.
yep. Okay. And then speaking of wills, there's a couple of folks just reminding in the chat, we partner with Free Will, and you can create a legally valid will for free at Free Will. And so there's a couple of links in there in the
Very cool.
chat. Yeah.
Very cool. Love it.
Oh, did we get just one more? I love all of the Taylor Swift uh, songs being called out. Um, Yeah, I think that this is so interesting, and we are definitely going to put together a blog post with some different kinds of resources for all of this and do a little bit of our blog writer is actually used to be, he's a former journalist. And so our blog posts are um, really meaty and rich. And this has been so wonderful. I think we are all good. So just a reminder, oh, somebody says there's one more question that hasn't been answered. I don't think so. Let me see if I can find it. Oh, he answered that. Yeah. Awesome. Well,
Great.
thank you all. This will be sent out to all participants. It will also be on our YouTube page. And then if you complete the survey, you'll be entered into a drawing for either the Cirque du Soleil or the I'm sorry,
Anna,
somebody in the chat is wanting to, she's saying you didn't say about how to get a letter of testimony. I don't know what that
oh,
means.
testamentary. So
Okay.
when someone dies,
Yeah.
so they've died, we take this original will along with a petition to the court to say this person died. I'm enclosing the initial. Wait, start over. I'm enclosing the original will, and the will appoints this person to be the personal representative of the estate. And judge, I'm asking you to admit this will to probate and appoint this person. And then the judge signs an order that says, sure looks like a will, and yes, you're appointed because the will says you're appointed. And the petition also says, and we want the judge to grant us letters testamentary. So when the probate is opened, when the person dies, the process is file the will, judge says go do it. You go down to the clerk's office, you get these, and it'll say King County Court related to the death of this person. This person's appointed as personal representative of the estate. I'll put the nice little stamp on. That's letters testamentary, or a letter testamentary. Because you died, your last will and testament. And that's how once a probate is open. Now that you have that, if you're the personal representative, because the probate got open because the person died, now you can take it and start opening up the accounts or doing whatever you have to do on behalf of the estate. I hope that answered the question. But that's
Including
what letters
filing
testamentary
taxes.
are. Same thing. You would enclose that with that tax return and it says, I'm the one who's authorized to do this.
Excellent. They say thank you for explaining that.
Oh, that's very kind of you. Yep, happy to do it.
All righty. Let's get that survey back up. Please complete. We would love to hear your thoughts and feedback. And thank you so much, James, and for everyone who joined us today. This was really, really interesting. Lots and lots and lots of information with lots of different scenarios.
Thank you, Anna. And thank you to everybody from United Way. Such a great organization. I'm so proud to partner with you guys.
Thanks all.